Um, and even though this is a true and false question, as you're answering it, I want you to think in your head of why this answer is true or false. So, state A allows 16-year-olds to apply for a driver's license. State B allows 18-year-olds to apply for licenses. Does state B violate the Equal Protection Clause? Okay. That's your question. I don't know where these chairs come from. They weren't here. All right. Okay. Who am I up to? Who's next?
I'm next.
Are you?
I'm Spartacus, yes.
You are Spartacus. Okay, that's a good one. Okay. First off, Braden, let me ask you this question, please. When the government treats people differently based on their age, as a general matter, is there a good reason for doing so?
This-
No, as a general matter, right? When
It can be.
there can be.
It can be a good reason.
Okay, well, why are we not very worried about treating 16-year-olds different than 18-year-olds?
I think in this situation, it's just kind of probably bumped up the age, so it's a little bit more safer. 15-year-olds a little bit more mature.
Ah.
Yeah, that's how I kind of view it. And it's on the lower tier
Mm.
scrutiny.
Well, we'll get to scrutiny in a minute, but as a general matter, do we have a problem with the law treating kids differently than adults?
No, we don't.
Okay. Kimberly, let me ask you a question a little bit differently, right? What if instead of cutting off the age of driving at 16 or 18, we said once you turn 70, you have to surrender your driver's license? I mean, I'm sure you have grandparents who you probably think they should give their driver's licenses. Maybe 80, whatever the number is. I'm sure there's a number, right? Pick a number, 70, 80, 90, whatever the number is, 100, right? You have to surrender your license. Does that make you a little bit more suspicious or a little bit more worried?
I mean, I think because it hasn't been done, yeah, but I could see from it coming from the health and safety of the public, I could see how some people would argue that, but I don't.
But why is age something that we can use as sort of like a bright line? Why is that something that maybe we could use?
Well, when it comes to driving, people that are too young pose a danger, and people that are, whenever you get to a certain age,
Yeah, right.
you know, you're less responsive and
Yeah.
to certain things.
Right. So we have insurance data, right, for example, right? I'm sure you know when you're a teenager, to insure a teenager is not cheap, right? If any of you have kids and they become teenagers, when you add a kid to your policy, the policy price goes up quite a bit. And also, when you are quite old, your premiums go up as well. I guess there's a sweet spot between, like, I don't know, 30 and 50. I don't know wherever that sweet spot is, where you're actually, a responsible driver. But then it starts going downhill because your vision starts to decrease, your hearing starts to decrease, your ability to respond to quick decisions, your response time decreases, right? But I don't think anyone would say these things raise constitutional difficulty. So the answer to this question, right, I think is false. And let's just see what you guys put up here. Damn, all right, 100%, very good. All right, but now let's say why. Only 20 of you here, but let's say why is the answer false. When we have equal protection cases, right, when we have cases where people are being classified or separated based on a characteristic, we have to ask ourselves a few questions, right? And the first question that we have to ask ourselves is, how is the government classifying people? And in this case, it's fairly obvious. The answer is age, right? If you're 16 In Texas, for example, get your license. Where I grew up in New York, license in New York City is 18 now. When I was here, it was 17. They've actually raised it to 18, so it's actually very hard to get when you're in high school. Is it 16 here, I think? Yeah, I got mine at 17. I failed my road test twice. Only test I ever failed in my life. Truthfully, yeah. Yeah, the first road test, I was actually about to pass, and I got so excited. I was like, oh my God, yes, and I blew a stop sign at the last minute. He actually ripped up my thing. He already printed it out and everything. I was so excited, and I just, yeah, I know. I was done, and he ripped up the thing. And then the second time I failed, I was doing the parallel park. Do you even do parallel parking for your road test here?
Yes.
Okay, yeah.
We don't fail if you fail that.
Well, that's why I failed. I parked fine, but as I was pulling out, I kind of clipped the car in front of me. So anyway, but I passed the third time. I passed the third. I'm a very good driver now, very good driver. But maybe I shouldn't have had my license at 17. Maybe another year would have helped. But when the government classifies people based on their age, we're not suspicious because we can rely on generalizations, right? Generally, younger people are less mature, and they are more likely to be unsafe drivers. And do I sound like a bigot for saying that? No, right? We are okay as a society with making generalizations based on age. For example, if you're a minor, you can't make a contract, right? You can't be liable for certain tort damages. If you're a minor, you maybe can't get married without your parents' consent. There are certain things you can't vote, right? You can't own a firearm. You can't purchase alcohol, right? There's certain things minors can't do, but they're based on generalizations. There might be some 17-year-olds who are really mature, and there might be some 20-year-olds who are very immature, right? A generalization, or you might call a stereotype, isn't always true, right? You might have a 16-year-old who's like a perfect, you okay?
Yeah, there's a bug, sorry.
A bug?
Yeah, it's flying.
Oh boy.
You saw it.
All right.
Must be the one that bit the aspirin.
We are okay. Speaking of maturity, right? Sorry, that was mean. That was mean. That was mean. I'm sorry. That was mean. I'm sorry. I have to. I'm sorry. That wasn't nice. I apologize. But we are okay with generalizations on the basis of age, because everyone grows up, right? You might have a really mature 15-year-old who's, a race car driver, right? Who's really good, and you might have a 20-year-old who's an absolute, terrible driver. But we still presume that the 20-year-old can go get his license, but the 15-year-old is not even eligible, even if he can perhaps pass the test, right? And so we say that age is a non-suspect classification. And I wanted to just explain what that means. When the government classifies people based on their age, we're not suspicious, right? We are, as a society, okay with generalizing people based on how old they are. That's how we've done it for years. You can't sign contracts. You can't do a lot of things. Okay? Everyone with me? All right. What about something like sex, right? Gender, right? Can you have these sorts of generalizations about gender? So I'll give you an example of a case we'll study next week. Let's say the state finds that men are more likely to drive drunk than women. Okay, men are more likely to drive drunk than women. Therefore, women can purchase beer at 18, but guys can only purchase beer at 21. That law is based on a generalization, or maybe a stereotype, right? The generalization is that men are less responsible, and therefore they have to be older to buy beer. Whereas women are more mature, they're more responsible, so they can be allowed to purchase beer at 18. The courts are more skeptical when you draw generalizations, when you make classifications based solely on gender, right? That's what I'm talking about. Are you classifying people based solely on their sex? So the courts describe sex as quasi-suspect. What does that mean? There might be some circumstances where sex-based classification is permissible. I'll use an example that may not even work anymore, but bathrooms might be one of them, right? That as a matter of law, you say people of one sex goes to this bathroom and people of that sex goes to that bathroom or locker room or shower, whatever you want to use. This is an example that comes up at the Supreme Court a couple times this term. Of course, it's crude, right? Because you're saying that this person can't go to this bathroom, that person can't go to that bathroom. But is a sex-based classification permissible? Probably not, but there might be some rare instances where it is permissible. Okay. But then we get down to the third category of classifications, which are called suspect classifications. Suspect, like suspicious, these are the classifications where we don't like generalizations, right? Where we don't like to stereotype people. And the most famous example in this category is race, right? And think of Brown, our reading from last class. The state said, we want to send black students to school A and we'll send white students to school B, right? What's the reason why you're separating these students based solely on their race? Is there any rational or legitimate reason why you're separating students based on race? No. The court basically says it's based on racism or white supremacy, whatever you want to call it. As a result, when racial classifications and racial stereotypes are used, the courts are very suspicious, right? Because they presume that the reason you're giving is perhaps not the real reason, but the actual reason is something that the court deems improper, which is racism. And the court said that purpose is not consistent with the Equal Protection Clause of the 14th Amendment. Okay? Everyone with me? Yes, sir, Braden.
What are the classifications would be under suspect classification? You said like.
Yeah, that's a good question. Generally, race is in there. Religion is in there. Those are the two biggies. There are not many super suspect. Oh well, race/nationality. Race and nationality are not the same thing, but they're very close. And most students don't know the difference. But you want to put race and nationality. In other words, race is, are you white, are you black? Nationality is what country you're from, right? Which will often be related to your race, but may not be the exact same thing. Also, the concept of ethnicity is in there, but ethnicity and nationality and race are often very closely intertwined. So the biggies are race and religion, but there are a couple of other subsidiary ones. The court, though, and I don't want you to get too hung up in this. I'll give you a preview of my next maybe week of class. These beautiful 3 tiers of scrutiny break down in the 90s. Right? Once we get to the gay rights cases, this thing kind of just goes out the window. The court doesn't really use it anymore. So I don't want you to get too invested in it, but you have to understand it. Right? Because someone says, where does gay, LGBT, it doesn't really fit here. Not exactly. Okay. All right. So we have here a situation where we have these various classifications. Okay. These classifications are not in the Constitution. Right? The Constitution says nothing at all about suspect or quasi-suspect or intermediate. None of that's in the Constitution. The courts basically made this up. And they developed this framework to make it easier, I think at least, for the lower courts to consider equal protection cases. It's like almost like a handy cheat sheet. And the idea is like this. Some kind of classifications are okay, like age, when it's non-suspect. Some kind of classifications are probably not okay, but there may be reasons to have them. And some kind of classifications are almost certainly bad. You can't have them. And so the crux of this sort of litigation is which bucket do you fit in? Do you fit in number 1, number 2, or number 3? Right? Depending which category you fit into, it almost dictates the outcome of the case. Right? If you have a racial classification, the government's going to lose. They're going to lose. If you have a non-suspect classification, the government's going to win. Right? That's generally how these things go. And with sex, the reason why I'm somewhat hedging on Braden's question is, in modern cases, sex and race are considered in a very similar fashion. Right? There's not much of a difference between a sex-based classification and a race-based classification. One of the few examples that Justice Ginsburg offered was actually bathrooms might be an exception, and I don't know if that even holds anymore. All right. All right. Now let's go through the actual concept of scrutiny. Right. This part you're going to have to memorize. I'll put up here in your notes, but you'll need to know this stuff pretty cold. With age, we apply something called rational basis scrutiny. We've used this phrase rational basis scrutiny in a couple contexts. But the idea behind rational basis scrutiny is one of deference. Right? There's one of deference, right? Which you might call the presumption of constitutionality. What does that mean? The court presumes that an age-based classification is legitimate, right? They presume that separating people based on how old they are is valid, right? Courts aren't troubled by this. And why? Well, everyone grows up, right? You might be 16 today, but you'll be 18 tomorrow, right? Maybe you don't get your license today, but you get it next year on your next birthday. I mean, it's not the end of the world, right? But people are born men and women. Again, that's a position that was once pretty popular, but doesn't exactly fit in with modern discussions. And you're born white or black, right? Your race is not going to change. Right? So don't ask me to Sammy Sosa, right? But generally, people's race is fixed, right? So here there's a position of deference. And I'll give you the test, and you see it framed different ways. Here's one way of framing it, but the idea is more or less the same. You ask, the government policy, that is the means, is rationally related, that is the fit, to serve a legitimate governmental interest, the ends. I want to just focus on this test for a minute. Okay? When you have this sort of scrutiny, you're always comparing the means and the ends, right? What is the government doing and what are they trying to do and how close is the fit between them? So let's take the driver's license example for a minute. Right? Why does the state give license to 16-year-olds or maybe gives licenses to 18-year-olds? They say, well, we adopt the 18-year-old policy. Those are our means because we want to promote highway safety. Those are their ends, right? How closely related are the means and the ends, the 18-year-old policy and highway safety? Close enough, right? Maybe there's some data showing that 16-year-olds are less safe on the highway, they're less mature, they get to more accidents, whatever the number is you want to come together. But the crux of rational basis review is you don't actually need evidence, right? You don't actually need any sort of evidence. This is what Justice Holmes would say, if reasonable people can reach this conclusion, it's good enough for me, right? If it sounds plausible that younger kids shouldn't be driving, that's enough. That's all you need to have. Everyone understand that point? Okay, so with a rational basis review, it's almost impossible to win. Because why? Because the burden is on the challenger to show that a law is irrational. Right? The burden's on the challenger to show that a law is irrational. That's very hard to do, right? You have to say that the members of the government who vote for this law were insane, that this law makes no sense whatsoever. And you're not going to do that. No matter how good of a lawyer you are, you cannot meet that burden. Because there's always say, well, maybe they did it for this reason, and maybe they did it for that reason. And you're never going to win. That's why New York has licenses at 18, and Texas and other states have it at 12. I'm sorry, not 12. Oh boy, that'd be fun. At 12-year-olds driving at 16. So you get your permit at 15? Is that the rule? Yeah, I got my permit, I think, at 16 and my license at 17. New York was really strict. In New York City, you couldn't even drive with your parents within city limits. You'd have to leave New York City to drive with your permit, unless you were with driver's ed. And I did driver's ed in Brooklyn, which was a mistake. Yeah. Yes, sir. New York? Not when I was a...
Up to a certain time to like 7 p.m.
Yeah, but that's outside of New York City.
No, in New York City. Until 7 p.m. and then after 7 p.m. you have to drive with an adult.
Maybe that was changed. I couldn't.
Yeah, that was a thing.
Is that a thing?
Yeah, and you could only use it to go back and forth to school or back and forth to
Is that new?
I was there when I was 16.
I did not have that. But you were not in New York City.
I mean, I was in Brooklyn for a period of time, and then I was in Long Island.
I could not in New York City. Was not allowed. Maybe something changed. Okay, probably for the best. I was off the roads. I don't know. Okay, so that's age. That's a rational basis classification. Any questions on that? Right now, I give age as an example, but really, everything that's not race or sex is non-suspect, right? You know, maybe the government classifies people based on their income, right? Where poor people have to go to certain schools they don't like, and they say, well, you're sending me to a bad school because I'm poor, right? Economic status is non-suspect classification, right? There are lots of ways the government can separate people. Maybe if you're a veteran, right? Veterans get certain benefits and non-veterans don't. That's a non-suspect classification, right? You have a disability even, right? The court has never held that people with disabilities are a heightened classification group. There's some statutory protections, but people with disabilities are considered non-suspect classes. So there are lots of ways in which the government can treat people differently that fall into this first category. Make sense? Okay. All right, the second category includes what's called intermediate scrutiny. And I'll describe it in a similar fashion as strict, but it implies we might call the presumption of liberty, which is Randy's phrase, which is the idea that the government presumes that the person is having their liberty violated, that the person is being treated unfairly. And the test is this. Let me put out the test for you. You say the government policy, that is the means, is substantially related, that's the fit, to serve an important governmental interest. Those are the ends. Okay? Let's do this one more time. Compare 1 and 2. Right? Compare 1 and 2. With number 1, you need a rational relationship. That is, does this make sense? With number 2, you need a substantial relation. A substantial relation, right? That means a fit has to be closer, right? Substantial is bigger than rationally, right? It means it's got more logic, more of a reasoning to it. And look at the second half, the ends. With the first category, the ends just have to be legitimate. That just means like not insane, right? Is this legitimate? Is this credible? With the second category, the end must be important. So you see a distinction, right? There's some goals that might be legitimate, but are not important, right? Everything's legitimate, right? If the government wants to have some obscure policy that might be legitimate, but it's not important. Now, someone's going to ask me, Josh, what's the difference between important and legitimate? It doesn't really matter, and I'll tell you why. What actually matters is not so much the ends, because it's always public safety. We're always doing it for public safety. Everything's public safety, right? That's always going to be legitimate or important. The ball game, poor choice of words. Sorry, too soon. If I sing Baby Shark, he'll throw me out of the room, right? What was that?
So please don't say Juan Soto's only 21 years old.
How old is he? No. Was it his birthday last week? No. Again, right? Again, every 5 seconds. It's still his birthday, I guess. The ball game. Oh, sorry. Again. The key question is the fit, right? Rational relationship just means, is there some conceivable basis on which the government's acting properly? The second test requires a substantial relationship. That means proof. The government must give proof, right? The government must give proof that their law is justified, right? The burden is on the government to show that the law is substantially justified. Okay, the law has to be justified by the government. So I'll use the beer example I gave you a minute ago, right? The state has to come forward and show that they have some data showing that 18-year-old girls are safer on the road than 18-year-old boys, right? But even then, in the case we'll study about the beer, the court said it's not enough, that your evidence is not persuasive enough, that what you're actually just doing is imposing a classification based on gender, which is not permissible, right? Under modern sex discrimination jurisprudence, the government almost always loses. I say almost always because it's sort of in flux, but it's going to be very hard for the court to uphold a sex-based classification. Yes, sir.
So for number one, let's say if you use an economic base, if the government's arguing,
Yeah.
this is income based, would your job as the challenger's attorney be to take it from that and say that that's just a prima facie fallacy, but in reality,
Race.
it's race?
Yeah. So I think Strozer's question is good. The crux of equal protection is getting yourself into the first category. Saying, well, they're saying they're doing it based on income, but it's really based on race. Or I'll give you another example. Think of Lee Optical, right? Remember the optician case, where if you were an eye doctor, you can make lenses, but if you were just an optician, a clerk, you could not make lenses, right? That's a classification based on licensing, right? Do you have this license or not? The Supreme Court upheld the Oklahoma law because it was a non-suspect classification. If you have this license to be a doctor, you can make the lenses. If you don't have to have the license, right? And the court upheld it, and Justice Douglas said, it doesn't really matter the reasons why, we'll uphold it always. But occasionally, if you can pigeonhole yourself into the race category, that's how you win the case. Good question. Any questions on the second one? We'll do gender cases next week. Oh yes, Nolan.
So if someone was to challenge an already existing, like the bathrooms, for instance, if they were to go to Supreme Court and say it's unconstitutional, does the government have to prove that it's substantially justified there?
I think so under modern case law. Yeah, they'd have to show maybe their issues of privacy, decency, maybe risk of violence. I mean, they're piece of evidence they could show. I'll put this out there. Every year I teach this question, I think the answer changes a little bit. But perhaps one answer is to ban urinals and only have stalls. Some professors actually recommend that if you ban urinals, most of the arguments go away. Right, the ladies may not know this, but in men's rooms there are urinals where you're standing up and there's not much privacy. If you ever go to like Minute Maid, it's basically a trough, right? Right? Yeah, it's basically this long basin. Think of like a trough at a farm, and there's no dividers, right? So I don't know how they work at a ballpark, but some law professors argue that the way to handle the bathroom situation is just make them all unisex with stalls, and not just stalls where you can see feet underneath, floor-to-ceiling stalls, right? If you ever go to an airport, you know the barrier goes up all the way, so there's basically no. In Asia, they have those. Basically, it's a room where you don't see what's going on next door. You don't really hear anything. So that might be one way. Well, the governments have separating based on sex, so just build these floor-to-ceiling stalls and eliminate urinals. And does the state have a compelling or an important interest in keeping urinals? Right? Lord help us if that gets to the courts. But so I mean, the answer to your question is not obvious. It's not obvious. I mean, there are even like white noise machines or things you can do to perhaps alleviate some of the other discomforts. I'm putting it out there, you'll think about it, but this stuff generally starts with law professors and comes to the government later, because law professors are dangerous. Yeah?
So their argument is essentially some of these professors install several single-person bathrooms?
Well, you have a huge bathroom with independent stalls, which are basically rooms. Yeah.
So like a Buc-ee's, essentially.
Yeah, exactly. If you ever go to Buc-ee's, the stalls are basically little rooms. Exactly. And if that's the case, you have to wash your hands next to a person, I suppose. And those, I guess, lesser concerns. There are some restaurants now where you have these private bathrooms and a single place to wash your hands, the unisex, the washroom. So I mean, it's not like beyond the realm of possibility that this is feasible. It's done in certain establishments. Bathrooms, yeah. That was a huge issue. The court had this the Title VII case, and there were a lot of questions about bathrooms. At the Supreme Court, the stalls don't go floor to ceiling; they go stalls. Yes, Nick.
So if the state makes legislation saying there has to be 2 separate restrooms, what rights do like independent bars and restaurants or places have to make just like unisex restrooms?
Well, a restaurant could opt to have unisex, but you're saying that's banned by state law? Is
Yeah,
that-
um,
I think the challenge would have to come from someone who's denied entry to a bathroom and saying it violates the 14th Amendment. I'll give you another example, the military draft. For the longest time, women were not subject to the selective service for the draft. And the rationale is that women could not engage in combat, and therefore there was no need for them in the draft because they couldn't do combat. That changed a couple years ago. Now women are eligible for certain combat functions in the military. There's a judge in Houston, maybe about a mile from here, who last year ruled that the exclusion of women from the draft violates the Equal Protection Clause. So ladies, now you have to register, right? People are shaking their head no. Equality sometimes sucks, I guess, right? But that might be a place where you would actually have to modify the selective service to have equal treatment. There are even mundane things like ladies' night discounts, right? Is that a form of discrimination where you charge females one rate to get into a bar, or maybe it's no cover at all, discount drinks, and guy pays a second rate for the bar? People are laughing, but there are people, I know one case in New Jersey where this guy keeps challenging these lady nights policies as being unconstitutional. Hey, you're laughing, but I mean, what would you say?
I'm sorry, you said New Jersey.
Yeah, well, I'm from that area. I know the case because he was always on the radio. He would go to these bars and he would be denied the ladies' night cover, and they would sue them. You're laughing. This is non-trivial. Right?
what was the outcome?
I'm guessing he lost, but I'm not sure. Yeah.
Doesn't there reach a point, things like that, where you're interfering with the person's right to run their private business?
Lochner. Lochner's not good law, my friend. Yeah. I like Lochner. Well, I have a love-hate relationship with Lochner. I like the dissent, but not Holmes. But under general economic liberty cases, you lose. All right. So the sex case cases when you get to bathrooms and lady night discounts and cover that you know. But then we have cases where you can't apply to a military academy for women. That's the Virginia case for next week. The draft one, I think, is going to be tricky because there was a district court ruling. I don't know if it's been appealed yet. I haven't kept track of it. But that one, under modern doctrine, it's hard to exclude women from the draft if they can now engage in combat. Not that we'll ever have a draft again, but you still have to register with selective service. So I don't know which way that case is going to go. This issue came up in the last Republican debates in 2016, and a couple of the candidates said, no, we have to protect our daughters, protect our girls, and then that's sort of stereotype that I don't think fits under the modern doctrine. But Kennedy's gone, so maybe modern doctrine isn't where I thought it was. Let's do the last one, race. Racial category is the easiest one to remember because it applies what's called strict scrutiny. And the thinking is the government should not be divvying up people based on race. That we have the Civil War, we have the Reconstruction Amendments, we have this entire period that was designed to help eliminate the vestiges of slavery, which are largely premised on racial classifications. Right? Dred Scott, go read Roger Taney. The entire thing was about racial classifications. Okay? And the test, and again, it's framed differently, but here's one formulation. The government policy, that is the means, is narrowly tailored, that is the fit, to serve a compelling governmental interest, that is the ends. I can never spell this word right. I think I've spelled it all 3 times. And this is for sure what you might call presumption of liberty. Okay? When you think of strict scrutiny, think again of the example I gave last class of the tailored suit. That you have this very, this was off the rack, I think. But you know, this actually from Hong Kong. If you ever go to Hong Kong, they have very good tailors, but they're very cheap. Like, so It's actually amazing. In Hong Kong, you go there and like basically in the morning you get fitted, and they have a suit for you like the next day, and it costs less than whatever you buy at Macy's. In fact, they keep your measurements on file. You can actually order; they'll mail you new ones as long as you don't gain too much weight. Seriously, they're very good. I'm not going to Hong Kong anytime soon. It's a little dicey now, but it's a beautiful city. Beautiful city. I love. I've been there 2 or 3 times. It's a lovely place, but it's not a little dicey. But think of the custom tailored suit, right? It fits perfectly, right? You can only use race when you have a really good reason to do it. There are only 2 instances that I can think of in American Supreme Court history in which a racial classification was upheld. And they're not, well, one's not a good example. The other one's a little bit, we'll do today. The first one is Korematsu, of course, right? Where they said, well, racial classifications are generally suspect, they're bad, but we have really good reason, national security. That doesn't work anymore, and I don't think that the sort of narrow tailoring they required was performed because this was a blanket ban on race. It was not limited to people who perhaps had evidence of being a spy or espionage or stuff like that. The second instance in which racial classifications are upheld is your reading for today, which is the affirmative action cases, the Michigan case as well as the Texas case, right? The court upholds racial classifications for what justification? Well, let's look at our test. What's the compelling governmental interest in the affirmative action cases? Foso, you're next, my friend. You're right on top. Sorry. You've been waiting patiently for almost 30 minutes. I know it's the worst, right? In the affirmative action cases, what is the compelling interest the government identifies to justify the affirmative action policies?
That you're talking about is narrowly tailored?
Well, yeah, it has to be narrowly tailored, but what interests are they serving? What's the compelling interest that the affirmative action policies are trying to accomplish? O'Connor and the other ones, what's the interest they identify?
You're talking about the first case?
Talking about the Michigan one, but Justice Powell talks about it as well in the first case. Right.
And they filed this.
What is the compelling interest that's used to justify the policies?
I know it's.
I'll come back to you.
No,
Yeah,
I know.
you got it?
I know it's the law school policy, right?
Why did the law school say they needed this policy?
To have a diverse student body.
Okay, you're close. Okay, but it's not just diversity. Why did they want diversity? What was the argument they had?
That the benefits of having
That's
diverse.
it. That's it. Okay, keyword is benefits. He said benefits. He's off the hook. He's done. Right? Thank you. In the affirmative action cases, both Bakke and in Grutter, with O'Connor's opinion, the court identifies an interest which they deem compelling. And the interests they deem compelling are the benefits that flow from diversity. Okay? The educational benefits that flow from having a diverse class. The idea is if you have people of different races, different backgrounds in your classroom, there's certain improvements to the educational and experience for the students. Right? That's the compelling interest that's identified. Now, Justice Thomas thinks that's not compelling at all. And we can argue about whether it is compelling. But that's the interest they're serving. The key question then becomes, again, the one of tailoring, right? Is the policy narrowly tailored, right? So think of the undergraduate policy at Michigan, where if you have a certain race, you get a bonus of X points in your SAT score, right? That's like the Kmart. That's like the Sears, right? It's using race in a very crude fashion. It's not using it in a very precise fashion, right? It's just, okay, if you're this race, check a box, you get all these other points. The law school, though, wasn't so blatant. It was more of a, they call holistic, right? More narrowly tailored, right? It was using race in a more strategic fashion. As little race as possible, as little fabric as you need to get to your goal of educational diversity. Everyone with me? All right, so when you have these cases, always identify what is the interest that the government's achieving, right? Is it compelling? and then ask yourself, how's the fit, right? Is it narrowly tailored, or is it a little bit too loose? Okay. Oh, and just to finish your notes off, the burden is on the government, with strict scrutiny, of course. The government must defend that their policy is reasonable. And there's a phrase that you'll see sometimes. You see, strict scrutiny is strict in theory, but fatal in fact. In other words, the type of scrutiny that you're applying here means that the government is almost always going to lose. That there are very few instances in which a racial classification will be upheld. And I gave you both of them. One is Korematsu, which is not the best case you want to go around citing. And the second is affirmative action cases, which continue to divide the court. Right? There's some issues that, over time sort of just go away. I think gay marriage is one of them. Just, okay, we have the decision now, all right, we're over it, right? Affirmative action's not, right? This issue has been divisive for half a century almost, right? And it's like the same issue that repeats in Bakke, repeats in Grutter, repeats in Gratz, repeats in Fisher number 1, repeats in Fisher. It's the exact same issue, right? Nothing's changed, right? I mean, we're getting further and further from the 1950s and 60s, but like it's the same thing that happens over and over again. I don't know how the next affirmative action case comes out with Kavanaugh off the bench. We'll get to the specifics in a minute, but I think the next affirmative action case may come out differently than did Fisher. I don't know the vitality of Fisher at all. It was a 4-3 decision after Justice Scalia died. I don't think there's a 5-vote block for that position anymore. So you guys are sort of in a flux period. I'll be here teaching the next case. You'll be long gone, right? But I think Fisher may not be long for this world. Right, if I had to pick any case in that 100 case that will be overruled or at least ignored, I think it's Fisher. That's my best prediction. Holowin's Health may actually be an abortion case, maybe chiseled back, but I think Fisher will not have much salience in a couple years. My prediction. What do I know? 101 cases, right? We haven't figured out if we want to add more cases, we just keep it at 100 or make it 125. I think we just keep it as 100, just add a few at the end. I'm still thinking it through. It's yeah, 100. Oh God, 200 cases, right? Everyone, yeah. It's hard because with a sequel, you want the title to be the same. I'm still thinking it through. Yeah, the honorable mention. Yeah, Bray. Plus 100 more cases. Yeah.
There's like one case coming out of Harvard and
Yeah.
schools.
Yeah, I'll mention that. Yeah, let me thank you for raising that, Braden. The next front in affirmative action cases are not white people bringing these lawsuits, it's Asian people bringing the lawsuits. So Barbara Grutter, no, what's her name? Jennifer Gratz and Barbara Grutter, I think I always mix them up, but Grutter and Gratz are both white women from Michigan. Abby Fisher was a white girl from Sugar Land. The next wave of the plaintiffs are Asians, who are a minority in numerical sense, but they are disadvantaged significantly by these various affirmative action policies. In fact, they draw analogies to how Jews were disadvantaged from colleges back in the early 20th century. About 2 or 3 weeks ago, a district judge in Massachusetts upheld Harvard's policy, and she found that it complied with the Fisher standard. Now you say, wait a minute, Josh, isn't Harvard a private school? Isn't it subject to the 14th? Isn't it not subject to the 14th Amendment? You're right, but there's a law called Title VI, right? Title VI is a federal law. You all know Title IX, that's like the educational sports funding, right? Title VI is similar. It says if you are a college that takes federal money, which is basically all of them, you have to basically not discriminate on the basis of race. So private schools are more or less subject to the Equal Protection Clause in that fashion. And the court found that whatever Fisher says, whatever Grutter says, private schools have to comply with it also. So there's one suit versus Harvard, and their policy makes it tougher for Asians to be admitted. And there's another suit against the University of North Carolina, which also has a policy that disadvantages Asian Americans. Again, I think the lower courts will uphold them under Fisher and Grutter, because that's what the precedents say. On appeal, I think the court goes the other way. That's my prediction. Okay. All Let me just make one more note, then we'll go into the cases. These three categories are all for equal protection. Okay. In about a week, we'll start the next category, which is called the due process clause, right? Or what you might call substantive due process. We've already done substantive due process in the early 20th century. Think of Lochner, think of Atkins, West Coast Hotel. But we'll get to the modern substantive due process cases, which are similar, right? In that you have rational basis scrutiny and you have strict scrutiny. But the difference is, with the due process clause, you're not classifying people. You're classifying rights. Right? Different types of rights are given different types of scrutiny. Right? So for example, if you have what's called a fundamental right, courts review laws that burden that right with strict scrutiny. Right? If you have a fundamental right, courts review laws that burden those rights with strict scrutiny. What's a fundamental right? Oh, the right to have children, the right to raise a family, the sorts of rights identified in Meyer and Pierce. Okay? And what if you have a right that's not fundamental, what's called a non-fundamental right? Well, what's non-fundamental? Economic liberty. Lochner, right? The court said that's not fundamental, it's not that important. Laws that burden non-fundamental rights are reviewed with only a rational basis scrutiny. We'll do this more later. I just want this in your notes so you can at least distinguish them. Now, someone's going to ask, Josh, what about intermediate scrutiny? Not quite. There's something called the undue burden standard. Right? The undue burden standard, which basically says the government can't burden a certain type of right if, the government can't enact a law that imposes an undue burden on a right. Right? The government can't impose an undue burden on a right. What kind of rights does this apply to? One right and only one right. Abortion. Right? The courts created an entire tier of scrutiny solely for abortion. We will do this like 3 or 4 cases on abortion. Right? Don't get too hung up. But undue burden, as it presently stands, is very similar to strict scrutiny. So again, if you're noticing a trend, number 2 and 3 tend to merge. They tend to come together. All right, so it looks like there are 3 buckets, but they're more like 2. I'm sorry, 2.5 maybe, right? But they sort of blend together. Okay. I want this just to be in your notes so you have the entire sequence straight. And if you have questions, we have in the video a discussion of this. I think our best video on this one is actually in the gender cases. We talk about the tiers more clearly. But be sure to watch the videos for the sex discrimination case for next class. This does make sense. Okay. Can we start the cases? Okay, we'll start the cases then. We have 3 eras today. Right? We have 3 periods of time. We have the Burger Court. We have the Rehnquist Court. And we have our beloved, our dearly beloved, Roberts Court. I think I'll outlive him, so I'll be teaching beyond his tenureship, but it'll be a while, another 20 years. I'll still be here. And what's remarkable about all 3 of these courts, which stretch over almost 40 years of time, is they're still fighting over the same damn thing, right? The same thing at issue in Bakke is still at issue in Grutter and Gratz. It's still at issue in Fisher. It's the same exact question. And the question is this: how can these institutions of higher education use race in their admission policies? All right. All right. The first case is Bakke. Angela, you want to give me the facts, please, in the first one, Bakke versus University of California, Davis? Uh-huh.
there was, Blake applied twice. He
Oh,
didn't-
Baki.
Huh?
His name is, it's pronounced Baki.
Oh, well, Baki applied
Yeah.
twice. He didn't get in. He didn't get in,
Did not get
both
in.
times, but his, scores were higher than most of the minorities they got in, so he finished the school.
Hmm.
And the school, well, after he finished the school, they said that, that their admissions process was unlawful. And the other one said that it was unlawful because it considered race.
Okay. All right. Very good. All right. Thank you, Angela. All right. So, the University of California had an admissions policy, right? And the admission policy worked like this. I'm not in front of the camera. The admission policy worked like this. There were a certain number of seats that were set aside for minority applicants, right? If you're a white applicant, you could apply to X seats, but if you were a minority applicant, you apply to the other set aside seats, right? Alan Baki was white. He could not apply to those 25 odd seats that were reserved for minority applicants. He argued that this policy violated the Equal Protection Clause of the 14th Amendment. Okay. The opinion split in a very ugly fashion, right? It split in a very ugly fashion. Actually, let me show you the video. I think the video is the best graphic to illustrate this. This case is what you might call a 4-1-4 split, right? A 4-1-4 split. What does that mean? There was no single position that garnered a majority of the court, right? We know there are 9 justices, and on the court, to have a majority opinion, you need 5. Right? Again, on the court, to have a majority opinion, you need 5. If you don't get 5, there's no majority. When you have less than 5, you have what's called a plurality. Like plural, right? A plurality. But that doesn't help people, right? How do we know what the law is when there's only a 4-on-4 split? So here's what happens in Baki. You have the 4 more conservative members of the court, and they held that the policy violated Title VII. Title VI. Title VI was this federal anti-discrimination law. So there are 4 votes who said that the policy violated Title VI. And then you have the 4 liberal members, Brennan, White, Marshall, and Blackmun, who said that the policy was just fine, right? That it didn't violate the 14th Amendment, and it didn't violate Title VI. And then you have Justice Powell in the middle. Justice Powell did not agree on the statute, but he agreed that the policy was unconstitutional. He argued that the policy violated the 14th Amendment. So there were 5 votes who found the policy was unlawful for different grounds, right? There was not a single member block that had 5 votes overall. As a result, Powell was considered the controlling opinion, even though he reached a result that no one else joined. Isn't that crazy, right? That one guy reaches a result by himself, and he has a majority. Why was his considered controlling opinion? It's a weird practice in the court where you take the most narrow decision, and his decision was considered the most narrow. I don't even know if this is correct, but this is how history is treated, so I'll give you what history has said. I want to focus for a bit on Justice Marshall's dissent. It's not in your book, but I want to mention it. We know, of course, Thurgood Marshall was the NAACP lawyer. He argued in the civil rights cases, like desegregation cases. And he argued a position that I think is at least more candid. He said the reason why we have affirmative action is not because it helps diversity. That is, because it helps other students learn. He argued, I think quite candidly, that the reason why you have affirmative action is to make up for past segregation and past Jim Crow and past slavery and everything that happened over the last 400 years in the Americas. And he says we should be candid about this, right? We should not try to say that we only need Hispanics and blacks on campus because they help other people learn better. He thought that was actually sort of a demeaning argument, that they're only there because they're useful. We need this instead to help give a boost to people who might otherwise be disadvantaged. Powell rejects that position emphatically. And he says we don't have a debtor and creditor race, that, you know, that one race is disadvantaged, and that we shouldn't have a system where one race is viewed as sort of the ward of the other, or that wants to protect the other because of past discrimination. So to this day, the only justification the courts look to is diversity and the benefits that flow from diversity. The courts do not consider whether affirmative action is necessary to compensate or make up for past forms of discrimination. That's usually the most intuitive reason why you would have these policies. And if I were to ask all of you, why do we have these? Say, oh, because, you know, slavery, segregation, right? That is not the policy the court adopts. So there's a certain, I don't use the word disingenuous, I think it's too strong of a word, but there's a certain like game that's being played where everyone knows what's going on, but no one's willing to admit it. Right? Everyone knows that, you know, Michigan was not a slave state; it was an abolitionist state, right? You didn't have a legacy of slavery in Michigan. Texas, you did. You didn't have that legacy of slavery in Michigan, right? But they were still trying to have this policy to make up for other deficiencies in racial equality that existed throughout the United States. The stuff about diversity is just, you know, it's nice. It gets you to court, but if you actually ask these people, they really think that's not what they'll tell you, right? And they'll say there's a racial justice component to it as well. But the upshot of the Powell opinion is that everyone now needs to make him happy, right? And that's, even now 40-something years later, that's still how these cases are litigated. All right. Questions on Justice Powell and Bakke? No? Okay. All right. All right. So Bakke's decided, was it 77 or 78? And then for about 20-something years, it wasn't entirely clear what the standard was, right? And in the early 1990s, a federal court in Texas ruled that the UT affirmative action policy was unconstitutional. The case was called Hopwood, H-O-P-W-O-O-D, Hopwood. So Texas created this alternate policy, this 10% policy, which we'll get to later. But throughout much of the 90s, at least in Texas, you didn't have an affirmative action policy. Another challenge was brought in Michigan. And it was a challenge to both the law school and the undergraduate admissions policies. All right, Caroline, let's start with the undergraduate, GRATS, which I know it comes second in your book, but I want to talk about it first. Describe for me how the undergraduate admission policy operated, please. Okay.
By assigning a number.
Good.
So certain races would get higher points
Very good.
in that system.
Yeah, very good. Okay, thank you, Caroline. The undergraduate policy was very, how we say, mechanical, right? For example, everyone was given a scale of 100 to 150 points. Like the thermometer effect, that's my idea. I think it was a good way of explaining it, right? It's actually harder, you think, to create graphics for every single scene in the library. It took a lot of time. This one, I thought the thermometer would be a good way of describing it. But every student was ranked on a scale of 1 to 150. 150 was the maximum score you can get. If you hit 100, you were admitted. Being a member of a minority group gave you 20 points off the bat. Right? having a perfect SAT score was not as valuable as having that sort of racial classification. Okay. The court here splits 6-3. Okay. The court here splits 6-3. And Rehnquist, Scalia, Kennedy, and Thomas, those are conservatives, are joined by O'Connor and Breyer. And the majority here goes along with the idea that to have strict scrutiny, you need to have some sort of narrow tailoring. And the undergraduate policy is not sufficiently narrowly tailored to meet constitutional scrutiny because it's automatic. The dissenters take a very different position, Justice Stevens, Souter, and Ginsburg. And the dissenters argue very vigorously that there's a difference between using race to help and using race to hurt. That is, using race to assist people, right? Using race to give minorities a bump up, a leg up, if you will, versus using race to harm people. Of course, I guess where you stand depends where you sit, I guess. For every student that's helped on one side of the ledger, there's someone who's denied admission. Or perhaps there's a minority student who's admitted, who would not otherwise be admitted, but the white student who was denied entry, Barbara Gratz, is denied entry. Justice Thomas critiques this one very strongly in his Fisher dissent, we'll get to later. Justice Thomas sees no difference between using race to help and using race to hurt. In fact, he compares very openly UT Austin and segregation. He says that the policies adopted by UT Austin are no different than the segregation policies at Brown. There's no one else like him on the court. He does not, he DGFs, right? Just none. Yes, if you're gonna get that, that's fine. But he's willing to say things that other people aren't. But the dissenters in this case freely believe that the affirmative action policy here is designed to help and ameliorate racial relations, and therefore it's consistent with the 14th Amendment. Now, Matt, let me ask you a question. How is it that in Grutter, the vote is 6-3 one way, but in the next case, Gratz, the vote flips, that O'Connor and Breyer now, with the liberals, goes 5-4 the other way? How do we explain this sort of flip from one to the other?
It has to do with the criteria that the law uses, in which it considers the race as one of multiple factors, as opposed to the undergraduate system of assigning a certain number of points.
Mm-hmm.
I think Justice Rehnquist indicates in the undergraduate thing, it's like for certain underqualified candidates, race is determined, where race is only a factor considered among many, and the law school initially did not find that to be unconstitutional.
Yeah, very good. Thank you, Matt. Justice O'Connor was something of a moderate. She was always somewhere in the middle. And Justice Breyer, I think he's one of those undervalued judges in modern history. He's often crafting compromises, right? In fact, there's some evidence that he was one who helped to persuade John Roberts in the Obamacare case to vote the way he did. In one of the Ten Commandments cases, he split the difference. He said, well, the Ten Commandments display in Austin can stay, but the Ten Commandments display in Kentucky has to go, right? And I think Breyer was very good at persuading O'Connor and also Roberts to take a more middle-of-the-road approach. I think he did this in a lot of cases after Scalia died as well. So I think Breyer doesn't get as much credit as he deserves. I think he's not the most flashy guy. He's sort of kind of boring. He's like, he tells grandpa jokes all the time. But I think he's valuable. Apparently he has knock-knock jokes every day that his grandkids tell them, right? He's always telling jokes to the justices, and apparently they're hilarious. I don't see it, but he's kind of like a funny guy. Breyer is known, though, for asking the longest questions at oral argument, because they're not really questions, they're just statements, where you'll speak for 3 or 4 minutes at a time, say, and what do you think? And I do this thing on my blog where I count how many pages his questions go on for. He'll speak, a transcript page, he'll speak for the entire transcript page, just Breyer, and 3 or 4 pages. And if you're a lawyer, right, and you have 15 minutes to argue, and Breyer asks you a 4-minute question, that's almost your entire time is gone by one stupid question. And you can't say, I don't have time for this. You can't, there's no time for this, right? You can't do that to Breyer, although you might want to. But he like thinks out loud. He's very candid. It's like whatever's going on in his head, he'll just say and talk and tell you what he's thinking about. And it's like, what do you do with this? I don't know. He'll say, here are like 8 things I'm thinking about. How would you respond to that? Okay, that's why Supreme Court lawyers get paid the big bucks. But I think Breyer and O'Connor drew a distinction. They said that the undergraduate policy is too mechanical, that it doesn't meaningfully consider race, and race is not narrowly tailored. And as a result, the policy does not survive constitutional scrutiny. Yeah, someone raise your hand? Okay. So the upshot is, after Grutter, the undergraduate policy was no good, but the law school policy survived. So what did every college in the country do? They said, oh, we're going to do what Michigan did, right? We're going to copy Michigan. Texas, which was not allowed to have an affirmative action policy for some time, decided to basically adopt the Michigan standard. Right? They basically said, we'll do what Michigan did. Or did they? Right, so that leads to the next case, which is Fisher versus University of Texas at Austin 1. Keep these straight. There are 2 Fisher cases, Fisher 1 and Fisher 2. I don't know why this is a practice, but in the court, when there are repeaters, they call them 1 and 2. Just keep it easy. Like there's Brown 1 and Brown 2. We have now Fisher 1 and Fisher 2. Abby Fisher went to Sugar Land High School. When I first started teaching, one of my students was her classmate, and they said no one liked her. Or, this girl, she was dumping on her, and she was like, yeah, she was on the bowling team, and I think she played the trombone or the French horn or something, and like apparently she was very awkward and whatever. I don't want to make fun of her, but like one of my students, she sat right there, right where Caitlin's sitting, right there. Sorry, not you, but it was. I remember the seats people sitting. I don't remember her name, but she sat right there. But she said, no one. She wasn't very popular. Also, she did not get into UT because she fell outside the top 10% of her class because it's a fairly competitive school. She went to LSU. I mean, it's not a bad school. I think they're number 1 now, aren't they? At least in football. But she went to LSU. Now she lives in Austin, and she does financial planning or something for one of the brokers. I don't know. Anyway, not important. Okay. Oh, my row's gone. Oh, Josh, you're there. Okay, I'm sitting, so I can't see. Josh, you want to give me the facts, please, in Fisher 1, or at least describe for me the how the UT admissions policy operated?
So we had like a two-step process type of thing in a way. There was like we had sort of like a holistic admission standard that kind of did like the law school, the Michigan law school, and then it was combined with Texas's top 10% law, which if you finished in the top 10% of your high schools, you were admitted into the public university of your choice. And then Fisher did not get in, and she said that it was based on, or she was challenging the affirmative action process, saying that it violated her 14th Amendment because it was on the basis of race.
Okay. All right. So a few points about the Texas policy. I mentioned a minute ago there was this case called Hopwood. Hopwood was a case decided in the mid-1990s by the Fifth Circuit, which ruled that the UT admissions policy violated the 14th Amendment. And as a result, the Texas legislature created another policy that was known as the Top 10% Plan. It was actually drafted by a law professor at UH. His name is Michael Olivas, who retired, I think, this year or maybe last year. That's Fisher, by the way. The way the Top 10% Plan was designed to work was to use race without using race, obviously. if you look at the demographics of Texas school districts, they're largely racially stratified. In some neighborhoods, the schools are going to be mostly white. In some neighborhoods, the schools are mostly black. In some neighborhoods, they're mostly Hispanic. That is based entirely on where people live and economic conditions. So the thinking was this. If we say top 10% of every high school, we know that there are some high schools that are almost all African American. So by definition, the top 10% of a predominantly African American high school will give us 10% African American students. And then there are some neighborhoods with predominantly Hispanic kids. And so we know with a very high degree of confidence that the top 10% of Hispanic neighborhoods high school will yield Hispanic students going to college. It uses race in an obvious way, but without saying race, right? It relies on the demographic breakdown of Texas to generate these sorts of numbers. That's what the policy is. It's not a mystery. The court tries to pretend that it's neutral, but it isn't. And I think Ginsburg says it's not neutral in her opinion. After Grutter, UT said we can't rely only on the top 10% plan, right? Even with this 10% plan, they still did not get what they called a critical mass of diversity, right? You need this critical mass of diversity. So they had to adopt this alternate policy which used race as one of many factors, like in Grutter. Now, Ethan, let me ask you this question. What does this concept mean, a critical mass of diverse students? What does that phrase mean?
I think it means that it was somehow lacking in number of specified nationality.
You said number, right? So is there a special number they want to achieve?
Not explicitly.
What's the problem with setting a number that you want to achieve? Why is that problematic?
Because then it would be racial. It would be a suspect classification.
Can you set a number?
No, sir.
Why not? What do you call that number?
It would be like a quota.
Quota. And what case told us quotas are not allowed?
Let's see here.
We only got a couple cases. Ethan?
Was it Regents?
Yeah, Bakke. Yeah, just call it Bakke. It makes it easier. Yeah, but collectively got it right. Bakke told us you can't have a quota, right? Remember, there were 100 chairs and only 25 seats for the black, for the Hispanic and black and Asian students, right? You can't have a numerical set aside. So here's one of the riddles of these cases. The court says you can't have numerical quota, but you can set aside seats to reach a critical mass. You know, thinking emoji, right? All right, the little monocle, right? How do you do that, right? You can't have a quota, but you need to have a critical mass. If you go back and you listen to your arguments, you want to see some good advocacy. When a Supreme Court justice asks you, how much is a critical mass? Answering that question, like giving a number, is very hard, but they do it well, right? And so they sort of just tap down and say, well, we'll know when we get there. We can't really tell you. But if you can't really tell us what that number is, how does it satisfy strict scrutiny, right? How do you have narrow tailoring? How do you have narrow tailoring if you can't even tell us what you're trying to accomplish, right? This sort of vague, undefined goal of having a critical mass of diversity, you can't even tell us what it is. So the issue in Fisher becomes this, one of deference, right? Always one of deference. Should the courts defer to the government, the school's definition of what a critical mass ought to be, right? Should they give deference to the government's policy, or must the government have the burden to defend its own policy? So this is where the affirmative action cases don't really fit with this very neat framework I gave you before. right? I gave you this framework before, which requires narrow tailoring to serve a compelling governmental interest, where the burden's on the government. But with affirmative action, it sort of moves a little bit, right? The narrow tailoring gets a little bit less narrow. The compelling interest gets a little bit less compelling. And the burden gets a little bit strict. Right? In other words, let's go one step at a time. What is the interest they're trying to achieve? Fossa told us this almost an hour ago, right? It's the benefits that flow from educational diversity. Is that compelling? Justice Thomas says absolutely not. Justice Thomas said there's no obligation for a state to have a law school. Alaska has no law school, for example. And there's certainly an obligation to have an elite law school, right? Michigan's a top 10, top 15 law school. It's a very good law school. I couldn't have gotten in there. Does the state really have an obligation to have a compelling, does the state have a compelling interest to have a elite law school? Thomas says absolutely not. Does having an elite law school match up with having national security? I think it's a stretch. So you see, the affirmative action cases watered down what it means to have a compelling governmental interest at a minimum. Now what about the fit, right? Narrow tailoring. The government says we need this policy, we won't really tell you why, right? We need benefits from diversity, we won't tell you what those are with any specificity. We won't tell you how many students we need. We will not tell you that number because that's a quota, right? Just it's a general notion of critical mass. We'll get there, we'll tell you when to get there. So instead of requiring narrow tailoring, you require a policy of deference where the courts will defer to the school's definition of what critical mass is, which is generally not how it works. It's not a matter of deference. So you'll see that the affirmative action cases don't really fit in here. And I think the reason why is because the Bakke framework is not very useful, right? The reason why these schools have affirmative action is not because there's some benefits that flow. It's to help give people a leg up. I think there would be it would be better if they were candid about it. And I think Justice Ginsburg gets at this in her Fisher dissent. It'd be better if there's candid discussion to this rather than simply doing this diversity dance. But that's the language they need to do. All right. Let's talk about Justice Thomas for a minute. His dissents are always provocative in this area. I think I've told you his life story, but I'll tell it to you again. He grew up with his grandfather. He was not raised by his parents. He was raised by his grandfather and his grandmother in a very poor town in Georgia. His grandfather, I think, was illiterate. But he instilled in his son, or his grandson at least, this sort of very unique work ethic. Thomas went to Holy Cross for college, and then for law school he was admitted to Yale. He was admitted through an affirmative action policy, in which he freely admits. And he regrets that he was. He thinks it cheapens his education. For the longest time, he said he put a cigar sticker on his diploma from Yale. He says only worth a few cents. He didn't think it was very worthwhile. And for the longest time, he actually boycotted Yale. He wouldn't visit there. He wouldn't hire law clerks from Yale. He just would not give it because he had such a negative experience. Eventually, he sort of had a rekindling, and he visited Yale, and they welcomed him. But it was like a 20-year gap. It was a lot of time. By the way, Justice Thomas finished paying off his loans after he won the Supreme Court, his student loans. So he still had debt when he won the Supreme Court. If you have your loans, you're a Supreme Court justice. You can pay them off. But Thomas views affirmative action very differently. He says affirmative action effectively treats people like they're not worth it, right? It sends a signal that you're here only because of your race. And that diminishes your credibility. When people see you, they think actually less of you. And he has this quotation from Frederick Douglass, the great abolitionist, who says, what do we want? We want to be left alone. We don't want these sorts of preferential treatment. Now, contrast Justice Thomas with Justice Sotomayor, who also wrote an opinion around this time. And Justice Sotomayor was also at Yale. I think she was a couple years before or after Thomas. Basically, Alito, Sotomayor, and Thomas were there all around the same period of time. So it must have been a good period. And Sotomayor was admitted also through affirmative action. She's actually proud of it. And she argues that she would never have been able to come up from her humble roots in New York City, in the Bronx, but for these policies. And she defends them vigorously. So you have, two people who both came from very, very humble roots, who went to the exact same elite Ivy League institution, who came out completely opposite perspectives of life. And I think it's a good way of illustrating that these issues are not always clear cut, and that you can't always look at a person and judge how they think about an issue. Thomas has very unique issues on race, and I think his dissent in Fisher. When I was first reading, I was like, "Wow!" I was just kind of stunned reading the first time. I was like, "Oh my God, Brown. Okay, here it is." You're not supposed to cite that Brown was wrong, but saying, Brown supports my position. So the Thomas Sotomayor dissents go in very different worlds. I think it's a useful contrast to have in the court. Any questions on that aspect of the cases? No one? The Thomas one is.
To Fisher?
Yeah.
Fisher
It's on
two?
Fisher two.
It's in your book, right?
It's on Fisher 2 and then Fisher 1.
Oh, I didn't put. Damn it! I'm sorry. It was a late night. No, those aren't in your book, are they? Well, I'm telling you about them. The Sotomayor dissent was somewhere else. That one is not in your book, but the Thomas one was. I have to remember. I do the same thing every year. Why is it? We have to put the Fisher, the Thomas dissent. Well, I know why. You have the Thomas dissent from Grutter, which I think gets most of his thoughts out. Oh,
He mentions Frederick Douglass and Grutter, right?
yeah, that one's in Grutter. Okay, let me describe it. The Fisher Thomas wrote a separate opinion, Fisher 1. Right? No, Fisher 2, right? Where he basically says that the motivations for affirmative action are no different than those of the segregationists. That's in your book, right? No?
Fisher 2 was,
It is Fisher 2.
yeah, he basically reiterates his 20, what I got was the 2015 concerns.
Yes. Okay. All right, but everyone get the gist of Tom's position wherever you see it. It's there. Okay. All right, so it's actually, yeah, Sorsh.
Why, it wasn't in any of the cases, but why was Justice Kagan?
Yeah, the reason why Justice Kagan recused is that she served as Solicitor General, and she was likely asked to review one of the affirmative action cases. And when you review and work on a case in government, you can't serve on it when you're a judge. Okay, but let's actually get to the issue in Fisher 1. I think you're next. So how does the court resolve Fisher 1? It's kind of a weird holding. It doesn't really fit with most of the other cases you study.
Didn't they say that essentially that? Well, they sent it back to the Court of Appeals because UT Austin didn't show that it was necessary for that their means were necessary for.
Right.
That they're trying to.
Right. In other words, did the majority in Fisher 1 think that the policy was sufficiently narrowly tailored?
No.
Okay, so then my follow-up question for you, Noel, is this. Why didn't the court just say, this is unconstitutional, let's go home and go start from scratch? Why did they send it back to the lower courts?
I guess.
The answer is not obvious. All right. usually when the court says that the law does not comply with strict scrutiny, the remedy is to declare the law unconstitutional. But here the court does something a little bit different. They say, well, we think the lower court applied the wrong standard. We'll send it back down to the lower court to apply the correct standard. Right? What were they hoping would happen? Want to take a guess, Nolan? What were they hoping would happen?
That the lower courts would declare it unconstitutional.
Good. And then would the Supreme Court have to take the case a second time?
No.
Okay. So here's some backstory. The hope was that the lower court would do the dirty work. There's a huge difference between the Supreme Court declaring a policy unconstitutional and the Court of Appeals declaring the policy unconstitutional. If the Court of Appeals declares a law unconstitutional, that ruling only has effect in Texas, Mississippi, and Louisiana, the Fifth Circuit, local courts, right? If the Supreme Court does it, that's a nationwide ruling. Now, why? Why did this happen? Here, there's a little reading in your book between the cases, which I encourage you to consider carefully. There's some evidence that after Fisher 1 was argued, there was a 5-vote block to declare the policy unconstitutional, which was set a nationwide ruling. Apparently, as the story goes, Justice Sotomayor wrote this blistering dissent, which I alluded to earlier, which she effectively charged the majority of being a bunch of racists. I'm not exaggerating by much. She says race matters, I think, 17 times in this dissent, which we saw in another case. She eventually published it somewhere else, but not in this case. And she said that the majority is sticking its head in the sand and ignoring obvious racism in Texas and the need to remedy it. And apparently this dissent persuaded, or at least had some effect on Justice Kennedy and maybe the chief. So as a result, instead of having a 5-4 decision declaring the policy unconstitutional, you now had an 8-1 vote. Only Justice Ginsburg wrote a dissent in the Fisher 1 case. And then everyone else sort of just signed on. Thomas wrote his own thing. Okay? And the hope was, okay, let's just sort of do this general opinion saying you didn't do the right thing and maybe the Fifth Circuit cleans it up. What happened? The Fifth Circuit does the exact same thing over again. They called their bluff, right? The Fifth Circuit said, yeah, no, we still think we're right. Can you imagine? Right? They just got reversed saying you did it wrong and they did the exact same thing over again. And so the case comes back to the Supreme Court. Okay? When certiorari is granted, it looks like there are 5 votes to overrule the policy. In fact, Justice Scalia was especially energetic during arguments. He alluded to what's called mismatch theory, which you may have heard of. It's this idea that when you admit a student to a school that's beyond his academic capacity, the student will do worse. In other words, it's better to be at the top of your class in a lower ranked school than at the bottom of your class in a higher ranked school. Whether it's true or not, people can argue for years. It's not my concern. But Scalia was asking questions about this, and people were going crazy, right? That was the arguments. But at some point after the case was argued, Justice Scalia died. He took a trip to a ranch in West Texas, and he went to sleep and did not wake up. He died February 13th, very memorable day. One of the consequences of Scalia's death is that term. A lot of cases that were going to go 5-4 could not anymore. Now, at this point, Justice Kagan was recused. Right? Justice Kagan was recused. So there were not 5 votes for the left. Right? Had it been 5-4, it would become 4-4. And when a case was 4-4, you simply affirm the lower court. But something happened. Again, Justice Kennedy perhaps changed his mind once again. And we get to Fisher 2, and we have 4-3 ruling to uphold the policy. Right? Nick, can you walk me through Fisher 2 and Justice Kennedy's decision upholding the UT policy?
Well, he essentially just reverses the position taken in Fisher 1, and he says that the class ranking rule alone is contrary to, it compromises the university's own definition of the diversity it seeks.
Okay. Versus courts, right? In the first case, he says we don't really have to give much deference to the university. But in the second case, in Fisher 2, Kennedy basically says that courts should not second guess how universities manage their policies, that they're the closest on the ground and they understand what's best intended to promote educational diversity. As a consequence of this, the UT policy survives. I don't think this case would come out the same way if Justice Scalia was alive. That's why I think that of all the cases, of the 100 cases in your book, this is probably the most vulnerable one. Because Kennedy's gone, Scalia's replaced by Gorsuch, Kavanaugh's here. I don't think this one survives. And I think you have a case like the Harvard one where it's a much more egregious affirmative action policy. I think the court sets it aside. So this is your current law. This is the law that you have now. I don't know how much longevity it has. Indeed, after Fisher 2 was decided, Ginsburg gave one of her famous interviews. The same interview where she called Trump a faker, and she started talking crap about Trump. She also said that Fisher 2 will be safe for a while. She said this because she thought Hillary Clinton was going to win and put Merrick Garland in the court, which did not happen. So this is a precedent I think will not stand test of time.
Kennedy seemed to also leave it open to review because he said the same policy might not be okay without finding.
Yeah, he sort of says this is a policy that's sui generis, right? You know what that phrase means? Sui generis, one of a kind. He sort of says, well, maybe this one's okay, but not judging anything else. In other words, it's a ticket good for one ride.
Well, it also means that it was only okay in that one instance. So
Exactly.
It might not even be okay for UT anymore.
Maybe. I think the better reading, so you often see this in cases where the judges say, this is a narrow ruling that only applies to the facts before us. So for example, Bush v. Gore, a very infamous case about the Florida election in 2000. And it's not my day today. And in Bush v. Gore, the court basically says, this is a decision good for only these facts. In other words, don't apply this anywhere else. Lawyers call this a ticket for one ride. You know, when you go to a train and sometimes you buy a ticket, it can be used all the time, or maybe a ticket for one ride. When you limit a case to the facts before it, it casts a lot of doubt on the reasoning itself, right? If this is only a reasoning that's good for one fact, why are we giving it? Aren't you the Supreme Court? Don't you give us these rules to apply everywhere? So this is, again, another reason why I think this decision is not long for this world. All right, so ultimately the UT policy was upheld. It's in effect now, but I don't know where it goes beyond this. Okay. Questions on Fisher 1 or Fisher 2? All right. I want to mention a few other points, and then we'll move on, or we'll wrap up. There's the other stuff in your reading on employment cases, which I didn't assign. You can read them if you want. But there are a lot of cases involving government contracting. That is, if you're a government agency and you want to award contracts, can you have racial set-asides? That is, you want to reserve certain dollar amounts of contracting for minority-owned businesses. And the courts have generally held that no, you cannot do that. Unless you're trying to remedy some specific act of discrimination, you can't have a general racial set-aside for employment. So the courts distinguish education from government contracting. Government contracting, the more stringent of how this stuff works. Most racial discrimination issues, though, don't arise in the 14th Amendment context. They mostly arise in the context of statutes, like Title VII. So for example, the Katzenbach case, the Heart of Atlanta case, and the barbecue case, Ollie's Barbecue, Katzenbach, right? That's where we see most racial discrimination cases. It's not in the constitutional context. Okay, any questions? All right, I will take pity and over your. I know you're all tired. I'm tired. I will see you all next week. If you want to come to my office, I'll probably be closer to 12. Be free today, or actually closer to 11:30 or so. But I'll be around. Okay. Thank you so much. Let's go Yankees. Baby shark.